Hi, my name is Alex Dolphin and welcome back to another episode of Ex Ante. Today we're going to discuss the case of Rowland versus Christian. This case was heard in the Supreme Court of California in the year of 1968. Let's go ahead and jump into the facts of the case. Rowland, the plaintiff, was a social guest at Christian, the defendant's home. Rowland went to use the bathroom, and when Rowland went to use the bathroom, he went to go turn the faucet on, and the handle was broken, and so the broken handle cut his hand really badly, severed some tendons, sustained a pretty serious injury. He was frustrated with this, so he brought suit against Christian, claiming that Christian was negligent. For Rowland to prove that Christian was negligent, he had to prove that she had a duty and that she breached it. So Rowland is proving that Christian's duty existed, and the duty that he wants to prove existed was duty to replace the handle and make sure it was safe for guests because she knew about it, and the evidence shows that she knew about the broken handle for 2 weeks. Or she has a duty to at least warn Rowland about the broken handle, and she did neither. So she breached that duty is what Rowland is trying to argue. The court looks at these facts and they deal with them through the lens of liability if someone's on your premises. So if you're a homeowner or a business owner or any type of property owner, when you have someone on your property, there's different classifications for those individuals, and the classification will determine the duty that you have towards them. So there had been some terms in the past before this case. There would be a licensee, an invitee, or a trespasser. A trespasser would be someone who just comes into the home without any invitation. Courts normally say that you have no duty to any trespassers to keep them safe in a negligence suit. A licensee would be a social guest. So typically Rowland would be a licensee, so a social guest, and you don't have much of a duty towards social guests. They take the property as they find it. And then an invitee would be a business guest. So if you own, a bodega or something, and someone comes into your bodega, they're an invitee, and you have a higher duty to protect and keep those people safe, right? So the court has these three classifications that they're dealing with, and they're looking at, and they're trying to decide where does Rowland fit. Rowland would normally fit into the classification of a licensee. The court says, and they kind of grapple with this, they don't talk about it, but if Rowland was to be a licensee, Rowland probably wouldn't be able to recover in this case. So that if they want to allow Rowland to recover, ex post, they feel like Rowland should be able to recover from Christian, then they need to find a way to nuance around these classifications. And the court doesn't nuance around the classifications too much. They just throw them out the door. They say, we don't care about licensees, we don't care about invitees, we don't care about trespassers. We say that if someone's on your property, you have a general duty of negligence to act in a reasonable way that prevents harm to foreseeable harm to foreseeable plaintiffs. So the court does away with those classifications of people that are on your land for purposes of duty and in a negligence suit, and they just say that you have a general duty to treat that person with reasonable care, and you have a general duty to keep that person safe if you know that there's a foreseeable harm coming to them. So that in this case would be Christian either warning Rowland of the broken handle or replacing it before he got to it. So they allow Rowland to recover. They throw the classifications out the window. Not all the judges are on the same page with this, so there is a lengthy dissent that says that these classifications of an invitee, a licensee, trespasser are important for purposes of liability, for purposes of duty and negligence suits, and we still should look at those and grapple with those and try and fit people into those classifications so that we can, have some efficiency in the courts and some predictability in the courts. So it's not a unanimous decision. There's a lengthy dissent that discusses the shortcomings of tossing the classifications out the window, and that's the case. The ex ante discussion that I'd like to engage in is one that kind of goes off of the dissent. Throwing classifications out the window doesn't really respect private property, right? If someone is a social guest on your private property, you have a same duty to them as you would a business guest, is what the court is saying when they throw these out. They're saying you just have that general duty. And if you just have that general duty, we're not providing for any nuances based upon that individual being on your property. We're really disregarding private property, and we're putting that down a rung in the law. And so I think that's one of the big implications of doing away with those classifications. On the positive side of doing away with those classifications is it might be easier to adjudicate disputes like this in the future. That's because we're just going to look at them through a general negligence lens. rather than look at them through, a general negligence lens through these classifications: licensee, invitee, and a trespasser, and then try and distinguish even more. And it might be it might be easier for judges to adjudicate these types of claims in the future if there are no classifications that they have to try and fit people into if they're on someone's premises for purposes of liability. So that's the video. Hope you enjoyed it. If you'd like to see more, go ahead and hit that subscribe button, and I hope you have a nice rest of your day. Bye-bye.